The opposition leadership opted for the judiciary route in its effort to push for the nullification of the Security Laws Amendment Act of 2014 that was passed by the National Assembly last Thursday and assented to by President Uhuru Kenyatta a day later. Court in the petition filed before High Court Judge Isaac Lenaola argued that sections of the new security law were unconstitutional and violate the rights of Kenyan citizens, including the rights to a fair trial and citizenship that are guaranteed in Chapter 4 of the Constitution on Bill of Rights.
The provisions of this statute are inconsistent with the Constitution. Virtually all the provisions contained in this particular law are inconsistent with the Constitution. And to that extent, or the extent of inconsistency, are null and void.
But court's legal team failed to convince Justice Lenaola to suspend the implementation of the Act pending the conclusion of the petition. The Government of Kenya and Attorney General Professor Githu Muigai have been named as respondents in the petition that has been certified urgent by Lenaola.
Whereas my prima facie views as to the validity vis-à-vis the Constitution, the wider interests of justice would determine that without hearing the respondents, a blanket order to suspend the law would be unfair. Fourthly, I heard Mr. Orengo to be saying that unless conservative orders are issued today, injustice will be visited upon innocent Kenyans. No particular case was cited in support of that submission, and I'm not satisfied that a case for grant of ex parte orders has been made out. I've also not been shown what prejudice the petitioners who near the specific person will suffer if no conservative orders are issued.
The state-funded Kenya National Commission on Human Rights also filed a petition similar to CORD's. The commission cites lack of sufficient public participation, misconduct of the National Assembly members when the bill was passed last Thursday, and failure to involve the Senate in the passage of the law as the basis for seeking the nullification of the security law. The commission also wants the process of identifying the Inspector General of Police stopped. The new security law gives the president powers to nominate the country's top cop.
My view is that, let me hear them. You've not lost the opportunity to get any ex parte orders, but let me have them here, and we'll manage it when they come in tomorrow at 11, okay?
But even as the judiciary determines the fate of the security law, the opposition team says it has other options at its disposal. This includes conducting nationwide civic education on the provisions of the Act and calling for mass action to protest its implementation.
Some people are testing our resolve. Somebody is testing our resilience. Jubilee is testing our willingness to return to the trenches and fight again for what we believe in and what we hold dear.
The Security Laws Amendment Act of 2014 is a collection of at least 109 changes made in various legislations touching on national security. The government maintains that the law was the perfect legal ammunition to tackle the challenge of terrorism and other forms of organized crime. The Security Laws Amendment Act of 2014 became operational yesterday when it was published in the Kenya Gazette. The court team insists that the law was repressive and draconian and an infringement on the basic rights of the Kenyan citizens enshrined in the Constitution. On the other hand, the government maintains that the court coalition was playing politics with national security matters. The judiciary has been called upon to arbitrate on this very serious and sensitive matter. Francis Gachuri, Big Question at the High Court, Nairobi.